Good afternoon. My name is Bill Boyd, and I'm here at the bar offices with David Walker. I am the current chair of the Business Law section, and David is a former chair of the Business Law section and also one of the Iowa commissioners to the Uniform Law Commission. We're here today to talk about proposed legislation from the Business Law section relating to amendments to a bill that was passed last year by the General Assembly and was also promoted by the Bar Association, and that was House File 2445. That bill amended the Uniform Commercial Code to add a new article to the Commercial Code to address controllable electronic records or digital assets. We have now gone back and looked at that legislation and are proposing revisions to it, and David will provide a description of the changes as well as the explanation as to why we are asking for this change.
But thank you very much, Bill. House File 2445 was a very important piece of legislation addressing transactions in electronic digital assets, if you will. The Business Law section and through the Legislative Committee of the Commercial and Bankruptcy Law section chaired by John Blythe followed the legislation and advocated very strongly because of the growing importance of digital assets on corporate and company and personal balance sheets, a year ago estimated to exceed $2 trillion. The Article 9 of the Uniform Commercial Code addresses the secured transactions in certain kinds of non-tangible assets. Article 9 addresses the interests of borrowers and lenders, electronic chattel paper, electronic documents of title, for example. Article 9 provides that a transfer to a secured lender for purposes of a loan can take place if the lender takes control of that, and it's defined how to take control. Other kinds of digital assets, cryptocurrencies, Bitcoin in particular, did not fall within those categories, was regarded as a general intangible under the UCC Article 9, and that created real problems for negotiability with respect to those digital assets, which are controllable electronic records under House File 2445. Previously, one filed a financing statement, but so often these digital assets can be transferred anonymously, and you don't know who the transferee is. If it's done through blockchain with care, sometimes the transferee can be found and the secured party or the owner can recover the asset. There is no bona fide purchaser rule here. That's a surprise sometimes to the transferee who, in good faith, without notice of the security interest in the digital asset, paid good faith and for value. So this is an important area for the law to address. The American Law Institute and the Uniform Law Commission have been working for a couple of years, and had produced a tentative final draft of a new article to the Uniform Commercial Code on controllable electronic records, which 3 states, Texas, Arkansas, and Nebraska, had already adopted. In conversations with members of the bar, the legislative committees, members of the credit union, representatives of the Iowa Bankers Association, there was strong interest in this kind of legislation, and it was adopted in House File 2445 with the understanding that the Uniform Law Commission was yet to approve the final version. And it was our understanding, communicated last year to legislators, that we would expect, if amendments were made, to recommend those amendments so that our commercial code would be uniform, as it's largely uniform throughout the country. Those amendments have been made. They're of 3 kinds. One, it revises the definition of control for controllable electronic records, digital assets that are not electronic chattel paper, electronic documents of title. And it does that essentially through the use, required use of a cryptographic key. The one who has the cryptographic key to the digital asset account on his, her, or her books is in control. And if that digital asset is to be the subject of a transfer, the transferee gets the cryptographic key, or if it's to a financial institution which maintains a wallet, if we're familiar with the term, the borrower will transfer the cryptographic key to the financial institution's wallet, if you were. So it provides very certain rules for control. It protects the interests of the original owner, any transferee, and anyone who purchases that digital asset. Second, House File 2445 did not address the issue of choice of law. The amendments which we're recommending do so. They have provisions on governing law. They are in short. One, just like any other contractual provision, the parties are free to state the jurisdiction whose law will control the transaction and the rights and obligations of the parties, just as in any other contract under the UCC. If they do not identify a jurisdiction, the default is to the District of Columbia, which has adopted the Uniform Commercial Code in its approved version in this article. It's viewed as a neutral jurisdiction, not a state, and so is Pressville. Finally, the definitions of control and other technical provisions for digital assets, controllable electronic records, are conformed to those in the UCC Article 9 for electronic chattel paper, electronic documents of title, and the like, so there is consistency in terminology and approach. In conclusion, I'd say that this remains a bill that financial institutions, banking interests approve. The American Bankers Association had representatives on the drafting committee, observers. They hired their own attorneys, their own law firm, Morrison Forster, out of San Francisco, and they voted for and support the bill. So we encourage this be made a part of the bar's legislative agenda so as to conform our UCC with the final and approved version of the Commercial Code.
Thank you, David, for that description. Again, this is a proposal from the business law section. We have been in discussions also with the commercial law and bankruptcy section, and they're in support of this legislation also. So we ask for the Board of Governors' support to include this legislation as part of the bar's affirmative legislation for the 2023 legislative session. Thank you.